Withdrawal, Consent, and the Limits of ICC Jurisdiction, the Duterte Case. A Policy Brief by Professor Morris Kiwinda Mbondenyi on Treaty Design, Institutional Legitimacy, and the Distinction between Criminal Responsibility and Adjudicative Jurisdiction, Factual and Procedural Background. Mr. Rodrigo Duterte served as President of the Philippines from 2016 until 2022, during which his administration's war on drugs resulted in the deaths of, by official figures, over 6,000 persons, with credible estimates suggesting as many as 30,000. The Philippines acceded to the Rome Statute in 2011, but withdrew on March 17, 2018, with withdrawal taking legal effect on March 17, 2019. An ICC arrest warrant was issued on March 7, 2025. On March 11, 2025, Mr. Duterte was arrested in Manila by Philippine national authorities, acting under the Marcos administration, and transferred to the ICC detention center in Scheveningen, the Netherlands, where he remains in custody. A confirmation of charges hearing took place from February 23 to 27, 2026. The jurisdictional appeal ruling is expected on April 22, the central jurisdictional question. The ICC formally authorized its investigation on September 15, 2021, more than 2 years after the Philippines ceased to be a state party. Jurisdiction is asserted under Article 127, 2, which preserves the court's authority over matters already under consideration before withdrawal takes effect, on the basis that a preliminary examination had been opened prior to March 7. That construction is, with respect, unpersuasive. The Rome Statute draws a deliberate institutional distinction between the court and the office of the prosecutor, Arts. 34, 39, 42. A preliminary examination is an internal, non-adversarial screening exercise, neither judicially authorized nor externally supervised. To treat it as a matter before the court conflates functions, the statute deliberately separates and renders Article 127 withdrawal rights substantially illusory. The Burundi precedent does not resolve this. There, judicial authorization preceded withdrawal. In the Philippines, it followed by more than 2 years. Criminal responsibility distinguished from adjudicative jurisdiction. The gravity of the allegations against Mr. Duterte cannot supply jurisdiction where the legal preconditions for its exercise are absent. If the court's Article 12 jurisdictional nexus has been extinguished by valid withdrawal, the continued exercise of adjudicative power on the strength of pre-withdrawal prosecutorial activity alone is legally untenable. Tribunals constituted by consent-based treaties cannot extend their authority beyond the limits of that consent by reference to the severity of the conduct in question. Complementarity, a burden not discharged. Article 17 of the Rome Statute establishes the ICC as a court of last resort. Admissibility requires a showing that the state concerned is genuinely unwilling or unable to investigate or prosecute. The Philippines enacted Republic Act No. 9851, specifically to address crimes against humanity in domestic law. The court has not demonstrated, with the rigor Article 17 demands, that Philippine domestic mechanisms were found genuinely wanting in terms of willful inaction or institutional incapacity, as opposed to being incomplete in scope or politically contested. Those latter circumstances do not satisfy the applicable legal standard, the circumstances of arrest and the appearance of impartiality. Mr. Duterte was not surrendered through a neutral enforcement mechanism. He was arrested by the authorities of a successor administration that had, by then, experienced a well-documented political rupture with Mr. Duterte. While state cooperation is indispensable to international criminal justice, The court's institutional integrity requires transparent engagement with the appearance risk created when a political successor facilitates the surrender of its predecessor to a tribunal whose jurisdiction remains under active challenge. Jurisdictional selectivity and institutional credibility. The court's prosecutorial record has featured defendants from African and Asian jurisdictions with disproportionate frequency. No allegation of bad faith is advanced. The submission is more fundamental. A consent-based tribunal that applies jurisdictional principles with inconsistency in a world of asymmetric political power will, irrespective of its intentions, generate perceptions of selective justice that are cumulatively corrosive to its institutional authority. The European interest. The normative authority of the European Union rests upon the proposition that a rules-based international order, applied consistently and without political favor, is superior to power-based alternatives. An argument the United States, as a non-party to the Rome Statute, is not well positioned to advance. That authority is, however, contingent. European institutions have a direct institutional interest in ensuring that the ICC's jurisdictional reasoning meets the highest standards of legal rigor and visible independence from political context, not in sympathy with any accused, but as a precondition for the credibility of the international legal order they champion. Conclusions and reform directions. Accountability for grave crimes is a legitimate and essential objective of the international legal order. Nothing herein diminishes the gravity of the allegations or the suffering of those affected. What is submitted, with respect, is that accountability pursued through jurisdictional overreach, bypassed complementarity, processes susceptible to political instrumentalization, and selective institutional application generates legitimacy deficits that are cumulative and ultimately self-defeating. The judgment of April 22 will test whether the court can meet these concerns with legal precision rather than institutional momentum. The proper response is textual clarification and treaty amendment, not judicial expansion by implication. For a tribunal whose authority rests upon the continuing consent of sovereign states, the distinction between criminal responsibility and adjudicative jurisdiction is not a technicality. It is the foundation of the entire system of international criminal justice. Reform directions for the full analysis. Express clarification of Article 127(2) to establish a judicial authorization threshold, a graduated withdrawal model, strengthened complementarity protocols, independent prosecutorial oversight, and greater utilization of universal jurisdiction in national courts.